Thanks, Mark. We're getting us started, and thanks for sponsoring the breakfast. And of course, thanks to the IMA for inviting us to be here today. My name is Dan Chafka, and I'm here with my colleagues, Megan Duffy and Jeremy Kriegel, who I think you've all met now. We all hail from the law firm Marshall, Gerstein, and Borun, which is located downtown in the Willis Tower. We focus exclusively on intellectual property matters, including patents, trademarks, trade secrets, and copyrights. Our patent practice, like Mark's firm, is divided by technology. Those technologies being mechanical ones, electrical and software technologies, biotechnologies, chemical technologies, and also a new group focused on medical devices. We're all members of the mechanical practice group. I'm originally from the south suburbs, Orland Park to be specific. I did all my schooling in Illinois. I got my mechanical engineering degree from University of Illinois in Champaign, my law degree from Chicago-Kent. In the past, I've worked at Caterpillar as an engineer and also at the United States Patent and Trademark Office as a patent examiner. My current practice is focused mostly on the prosecution and preparation of patent applications. I work with an array of different size clients, ranging from startups all the way up to Fortune 500 companies. And I focus mostly on mechanical, electrical, some electrical type applications, and also some software applications. Megan and Jeremy, would you like to introduce yourselves?
Sure. I know that I've personally met many of you this morning already, so thank you again for coming. It's very nice to see you. As Dan said, I am a member of the mechanical practice group at our law firm. I too advise large and small clients with their patent issues. In particular, I prepare and prosecute patent applications for the mechanical technology, the electromechanical technologies, medical devices, consumer products, software, and the insurance industry. I'm also from the Chicagoland area. I was born and raised in the south suburbs, grew up in Evergreen Park. Went to U of I as well in Champaign. I have a general engineering degree, which is a combination of mechanical and structural engineering. And then I went to Loyola University Chicago for law school. So again, thank you for coming, and we look forward to having your participation in the presentation.
Thank you. I'm Jeremy Kriegel. I am the chairman of the prosecution practice group for Marshall, Gerstein, and Borun. I also have a mechanical engineering degree from University of Rochester in New York, and my law degree is from Washington University in St. Louis. I've been in practice for 20 years with the firm, for 15 concentrating in mechanical patent prosecution. I also have some experience in litigation and transactional matters, mostly patent licensing and transfer of patents. This is a small group, so we're definitely open to questions and making this as interactive as possible. We're going to just try to give you a real sort of nuts and bolts patent, trademarks, and copyrights 101, just to give you a very brief lay of the land of some potential issues that you and your companies and your clients ought to be thinking about as you go about your business and the many issues that you face. So, without further ado, give the mic back over to Dan.
It looks like we're being reminded that there's a presentation to do today, all right? Okay, so just to give you an overview of the presentation, there's going to be 3 parts. Each of us will speak to one of them. They should each be about 30 minutes. We may take a break after the second part. I'll start us off with an overview of intellectual property and where patents and trademarks fit into that framework. Then Megan is going to dive into the nuts and bolts of obtaining a patent. And then finally, Jeremy is going to close this out with design patents and the basics of trademarks. Okay, so to hopefully pique your interest in this topic, I put up these interesting statistics I found and put together the presentation. We're in the middle of what might be considered a patent boom right now. 600,000 patent applications were filed last year, which is the highest number ever, and it's up about 350% since 1990. I found a study by the Brookings Institution that the average patent is worth about $500,000. Now, of course, there's patents that are worth a lot less than that, and some that are worth far more than $500K. You've probably seen in the news recent patent litigation between some of the tech giants where there were verdicts with damages over $100 million. In some of those cases, only involved one or several patents, so those patents were obviously worth a lot more than $500K. Those news stories, though, kind of lead the perception that patents are only for giant companies, ones that have legions of engineers and scientists, and that's certainly not the case. There was a study by the Small Business Administration that found that small businesses, at least the ones that are engaged in patent activity, produce 16 times as many patents per employee as large businesses. So it's not absolutely necessary to have a large R&D department to produce patentable technologies. Forbes estimated Apple's brand to be worth about $145 billion. So this is not that doesn't include any of the tangible assets of Apple. This is only the intangible brand is worth that much. And one of the main ways they protect their brand is with trademarks. And then finally here, this last stat is from a Senate report, and it found that IP theft diverts about $250 billion away from U.S. companies every year. So the onus is on companies to protect their IP, and one of the ways to do that is with patents and trademarks. So before diving into the legal aspects of patents and trademarks, I'd like to give an overview of how intellectual property factors into the economic model of a business. So you can think of a company as having two primary classes of assets, tangible ones and intangible assets. Tangible assets, of course, are the physical resources of the business, including its. I have some accountants in the room, so they could correct me here, but this is just to be a primer for where we're going. So tangible assets are the buildings, equipment, inventory, cash on hand, things like that. The intangible ones are, of course, the non-physical resources that impart value to the business because they give the business some competitive edge. And those include the company's reputation amongst its employees and its peers, the financial assets of the firm, its stocks, bonds, other contractual obligations owed to the firm, the know-how and experience of its employees and owners, and then finally its intellectual property. And intellectual property is an umbrella term. I'm sure you've all heard it, and it includes patents, trademarks, copyrights, and trade secrets. In its most basic sense, intellectual property is a series of rights that one can obtain to stop copycats. I think that's the easiest way to think about it. Essentially, intellectual property rights are a monopoly that's granted by the government in reward for creative endeavors. So you may be thinking to yourself, well, isn't the government usually trying to stop monopolies? Usually you hear the EU's trying to break up Google, or you hear politicians railing against breaking up the big banks. And that is true. Generally, monopolies are not viewed favorably, and that's because they deter competition and lead to higher prices for consumers. The reason why IP rights are given a monopoly is because we see IP as playing a critical role in the progress of technology and artistic works. And one of the ways to encourage people to create these new technological innovations and artistic works is to give them a monopoly over their inventions. Now, patents, trademarks, copyrights, trade secrets, they cover different types of subject matter. They have different terms, and they're obtained in different ways, although there is some overlap. And so I like to go over some of the basic distinctions now. Patents deal with inventions, particularly how an invention works and how it looks. It comes with a bundle of rights, and they're all listed up there. So a patent will allow you to exclude others from making, selling, using, offering for sale, and importing an invention. Now that's a fairly broad range of rights, so if you are a patent owner, it will allow you to charge a premium for your product because you will keep competitors from doing any of those things. Now there are limitations though on patents, and first and foremost one is that it has a limited term. It only lasts for 20 years. A second major limitation is that they are limited geographically. So in each country in which you would like patent protection, you typically have to file a patent there. So what that means is that if a Chinese competitor is making your product in China and selling it only in China, you cannot use a U.S. patent to stop the Chinese competitor from engaging in that activity. You would need a Chinese patent to do that. Also, patents are obtained by applying to the U.S. Patent Office, and the Patent Office will review it very rigorously and determine whether or not what you have filed on includes patentable subject matter. Trademarks don't deal with inventions, they protect a company's brand. And what I mean by that is any words, names, slogans, logos, or any other symbol that exclusively associates the company's product or service with that company. And the primary goal of trademark law is to prevent consumer confusion. So the idea is that if we can find a way to help consumers be sure that the product they're buying is actually from a particular source. So for example, if a consumer sees a can of soda at the grocery store and it has the Coca-Cola logo on it, the trademark law is intended to ensure that the consumer will know that that Coca-Cola logo means that that can of soda came from the Coca-Cola company. One major difference between trademarks and patents is that trademark rights arise from their use in commerce. There is not a use in commerce requirement for patentable inventions. In fact, you do not want to use your invention in commerce before you file for a patent. Also, trademarks don't have a limited term. They can last forever, so long as the mark is continued to be used in commerce. Now, briefly, I'll just cover these last two just to give you an idea of what copyrights and trade secrets are. Copyright protects any original work of authorship. This is generally artistic works, and so plays, books, songs, movies, television, those types of things, and certain other intellectual works like software and possibly the design of a website. Unique thing about copyrights is that there is copyright protection arises as soon as the work is fixed in a tangible medium. So you don't have to apply to the patent office, for example, to obtain a copyright. As soon as the work is created, it's protected by copyrights. Now, you can file a copyright with the government, and there are benefits of doing so, but I won't get into that here. And then finally, trade secrets. This is confidential information that a company makes reasonable efforts to protect and keep confidential, and also has some economic value because of its secrecy. Examples of things that could be protected as a trade secret are a prototype that's only used internally within the company, a secret manufacturing process that a company uses to manufacture a product, maybe custom-made software that's only used internally within the company, and test data that arises from testing a prototype within the company. Now, there are limitations to trade secrets, and one of them is obviously if the company either intentionally or negligently allows their confidential information to be disclosed to the public, then that trade secret would be lost. And then also if another independently develops the concept that is the subject of the trade secret, there's potential for trade secret protection to be lost. So you can think of like if a company produces a product by a secret process and then sells that in the marketplace, and a competitor reverse engineers that product without having any access to confidential information, their trade secret law cannot be used to stop the competitor from making that product because they developed it independently.
So I have a question about that. So trade secret, I'm obviously not going to file it because I'm giving away my secret.
That's
right?
correct.
So how do I prove that it's mine? This is all document trail that I would show.
Exactly.
Evidence.
So you have to show that you have procedures in place that, employment agreements that and NDAs that keep your employees under a contractual obligation to keep those things secret.
It seems really messy. It's got to be really messy. Because I mean, it's been my secret for like 20 years, right?
mhm.
And I don't even want to write it down. Because it's a
Well,
secret.
it's the standard is reasonable efforts, reasonable business efforts to keep it secret. So, you know, there's of course some things that you have to write down or store on your computer, and as long as that's considered to be a reasonable effort, business effort to keep it secret, then you should be able to keep your secret a trade secret.
Like the flavoring in Bona Italian beef.
So here, that's the actually very similar example here. So a Coke can embodies all 4 different types of intellectual property, incidentally. It's like a secret recipe is something that could be protected as a trade secret, and Coke protects the recipe for the Coke syrup itself as a trade secret. And that was a strategic decision on their part, because they could have filed a patent on it originally back whatever 100 years ago. If they did that, though, it would only have lasted 20 years, and then it would have been free for anyone to copy. Since they've kept it as a trade secret, its protection, it will be protected indefinitely so long as they're able to keep it as one, and no one else independently develops it. The name Coca-Cola is trademarked, of course, and then there's another subset of trademark protection that one can obtain. It's called trade dress, and so that's kind of how the look and feel of the can. So it would be something like the combination of the ribbon on the can and the placement of the text and the coloring, and how the combination of those things connotes to the user that this can is from Coca-Cola. Looking at the back of the can, there's text there describing the company and the product, and that's subject to copyright protection. And then the Coke's website could also be protected with a copyright. And then finally here, there's various aspects of the can that can be protected by patents. And I think it's important here to recognize that any single product probably can be protected by a number of different patents. And that's because most products involve a number of different inventions. It's usually not just one. So here, the pull tab at the top of the can could be subject to a patent. It's probably not anymore because pull tabs have been around for a while. So the structure and function of that pull tab, so how the user's rotation of the tab pierces the lid and creates an opening, that concept, that structure and function together is something that could be protected with a patent. You could protect the shape of the can, maybe particularly the bubble at the bottom and how the shape of that bubble prevents the can from bursting. And a variety of other things could be protected in terms of the can structure and functionality. Okay, so now we'll move on to patents. So the philosophy, what is the philosophy of the patent system? So actually the basis for the patent system is found in the Constitution. So even the Founding Fathers thought that having a patent system would be an important part to a democracy, which I think is very interesting, that people had that much foresight back 300 years ago. And I kind of touched on this before. It's the idea of a patent is to promote progress and technological innovations by encouraging public disclosure and development. So there's a trade-off here, and it's that if the government is going to grant you these monopolistic rights in your invention, then you have to tell the government and the public how to make and use your invention. If you don't want to do that, then you would keep it as a trade secret. The rights from a patent, I mentioned it before, it's those bundle of rights, making, selling, using, and importing, and it's only the right to exclude others from doing those things. And so a patent doesn't give you a right to practice your invention, and this is an important concept and a difficult one to understand. So there's a common analogy that's used, and it's that a patent is a sword but not a shield. And what that means is that you could use your patent as a sword to stop others from making your invention, but you can't use it as a shield to protect yourself from another competitor accusing you of infringing their patent. This could happen if a competitor had filed for a patent that is extremely broad and is broad enough to cover your invention. That could stop you from practicing your invention. Practically what this means is that even if you develop a patentable technology, you should still consider whether or not there are patents, pre-existing patents that cover your product. And I mentioned before that patents are limited geographically, and one of the benefits of patents is that they're enforceable through the courts. Patents maybe 50 years ago or so were not considered to be as strong as they are today, and that's partly because of the creation of a special appeals court in the 80s called the Federal Circuit. And this court specializes in patent matters, so there's usually appeals courts hear cases on all subjects of law. This court hears all of the patent cases, and the benefit of that is that they've brought predictability to the law, and then that in turn has resulted in patents which are more likely to be enforced. So here's some of the business benefits of a patent. Of course, it deprives your competitors of leading technologies. And in terms of a smaller company, I think one of the things that a patent will do is level the playing field for you. So if, let's say a small company has invented a new gizmo and releases such thing in the marketplace, a larger company could step in without patent protection. A larger company could step in and begin replicating that product. And because of their economies of scale, their greater distribution networks, their greater marketing activities, they may be able to obtain a larger market share than the smaller company. A patent stops all that, and that's a very important function of a patent for a smaller business. It also creates barriers to market entry. It stops new competitors from stepping in the field and producing copycat devices. It's an asset that increases the value of the company. As I mentioned in the first slide, an average patent is worth about $500,000. It can be used to create a stream of revenue by requiring competitors to license the patent from you to practice your technology. It can be used in defensive terms. So if a company is accused of infringing another's patent, it's oftentimes a place that company can find a patent in their own portfolio and sue the original company for infringing one of their patents, and that will lead to most likely a cross license or something like that instead of litigation. So it's kind of, I like to think of the metaphor, it's like in the Cold War, mutually assured destruction. Each country has so many nuclear weapons that no one would attack each other because it would lead to both of their annihilations. Finally, patents foster reputation as a leader and an innovator. I think some smaller companies like to use patents as a way to show their consumers that the product they're buying is leading edge technology. And may give the customer a competitive advantage in their own industry. They're easier to enforce than other types of IP. That's because they're presumed valid. The process of going through the patent office and having them rigorously review your patent leads to this presumption of validity. And then finally, companies that implement patenting systems may find that there's an increased climate for innovation, and it provides sometimes a morale boost for your engineers and other employees. There are three types of patents: utility patents, design patents, and plan patents. Utility patents protect the functional aspects of the device, whereas design patents protect the visual appearance, and the legal terminology is the ornamental appearance of an invention. And then finally, plant patents here protect plants and seeds and other things like that. There are two ways to file or apply for a utility application, and they are a provisional application and a non-provisional application. A provisional application can be thought of as like a placeholder. It gets your position in line at the patent office. But a provisional application is never examined by the patent office and will never turn into a patent unless it's converted into a non-provisional at some point. So you may ask, well, why would I ever file a provisional application if it's never going to turn into a patent? And the reason is that a non-provisional application takes time to prepare. And if you're in a rush to get your place in line at the patent office so that no one beats you there, you may want to file a provisional. And a provisional has less formal requirements. You can file essentially, just a lab notebook with notes from an engineer describing the invention. That could be enough to file a provisional application. You don't have to have formal figures, claims, or a formal written description. Provisional applications are not disclosed to the public, so if you dump all your information in the patent office in terms of a provisional application and you decide, well, we want to further develop or don't, we're not going to pursue this, it will be kept secret from any of your competitors. Now, a provisional application, though, expires after 1 year. So if you don't convert the provisional into a non-provisional before 1 year is over, then your rights are lost. And so a non-provisional application, one of the main differences is that it does publish after 18 months. There are steps you can take to prevent it from publishing, but if you do that, then it prevents you from filing in foreign jurisdictions. Okay. So after
You're saying my application is published, it hasn't been approved.
Right.
It hasn't been approved, but the application is now being published, so all my competitors
Will know.
see it, and I might get declined too.
That is correct.
So it's real risky.
Right.
Okay.
So after you've applied, the patent office will examine your application for a number of requirements, and here are the four main ones. First of all, the invention has to be directed to patentable subject matter, and this is defined by a statute, but there are a lot of different patentable things. So you have devices, and it's not just physical things, it's also methods. So methods of manufacturing, methods of using a product, also the materials used to make the product, and then also certain software and business methods. So business methods are a way of conducting business. Those last two, software and business methods, have come under more scrutiny by the Supreme Court in recent years. So it's more difficult to protect those areas, but there are creative ways of doing so. The next requirement is that the invention be novel, and what that means is that the invention has to be new, in essence, and it could be only a minor difference from what the pre-existing product is. So let's say a very simple example here, you've invented a pencil that's an inch longer than all known pencils. And there's no pencil out there with a similar length. That would be new, but that does not mean you will receive a patent on that technology, and that's because of the next hurdle here, non-obviousness. And what non-obviousness is that you have to prove that your invention would not have been obvious to a person of ordinary skill in the art to modify a pre-existing device to arrive at your invention. So going back to that pencil example, if it would have been obvious to a person to make a pencil just an inch longer, then most likely you will not receive a patent on it. Ways that you can prove to the patent office that it would not have been obvious is to show that perhaps there was a teaching in the art that it would not have been a good idea to extend the pencil an extra inch because of cost concerns, or maybe it makes using the pencil more difficult. Another way is to demonstrate that the inch extension that you have developed makes the pencil easier to balance in your hand. So some kind of unexpected advantage has resulted from your modification. And then finally, you have to properly disclose your invention to the patent office. This is a very legalistic area, but in general, the patent must describe your invention in a way that a person of ordinary skill in the art could make and use your invention simply by reading your patent. How early must you apply? So in general, the earlier the better, and that is because of a recent change in the law. The United States recently transitioned to a first to invent system, and that contrasts with the previous, first to file system, which is different from the first to invent system that existed in the past. What that means is that the first person to file on an invention at the patent office is the one that is considered to have priority in that invention. So for example, if a company develops a product but doesn't file, and a competitor in the meantime files an application, then even though the first company was the one to first develop the invention, they would not have priority in it because they were beaten to the patent office by the other company. And that was not the case before. In the past, it was whoever invented it first was the owner. This is a recent change that happened within the last 5 years. There's other things that can trigger a race to the patent office, and one of them is a public disclosure of your invention. If your invention is shown at a trade show or even offered for sale, even if the sale doesn't result in an actual purchase, that's considered to start a 1-year clock in which you need to file your invention before that clock expires. Generally, this is called the 1-year grace period. Generally, it's advised not to rely on the 1-year grace period for a variety of reasons, but one of the main ones is that in foreign countries there is no grace period. So if like I said, if the invention was disclosed at a trade show, you would most likely in most countries not be able to file for a patent on that invention anymore. Okay, so that wraps it up for me. Is there any questions anyone has right now? If not, we'll have another Q&A at the end.
So, from a Japanese company, we have patents in Japan. They're not valid in the U.S. Is this the geographic limitation that you described?
That is correct. A Japanese patent could not be used to stop a U.S. company from making, selling, or using the product in the U.S. If the U.S. company was making it in Japan, that Japanese patent could be enforced against the U.S. company.
However, you can take your Japanese patent and you have a year to file it in the U.S. And so then you can get a U.S. patent based on that Japanese patent. So once the Japanese patent is filed, you have a year to file in the U.S. So then you could have your protection in the U.S. And you can do that in other countries too, right?
Right.
Like in Europe and around the world.
How similar are the patent applications between jurisdictions?
So that's a good question. The requirements do vary amongst the jurisdictions. Generally, they're very close, at least in terms of the drawings and how they're to be displayed. There are some differences in how the claims are written and what subject matter can be protected. For example, in Europe, methods of treating the human body cannot be protected, whereas in the U.S. they can. But it varies a lot actually between countries.
Does the European community have a standard that they share? Like if there's a patent in the UK enforceable in France?
So there is a patent that can be applied for called a European patent. And that's examined by the European Patent Office, and that's kind of like under the EU framework. If the European Patent Office grants a patent, then the patent, for that patent then to be enforceable in individual EU countries, you have to apply to the individual countries. But the good thing about the European patent is that generally if the European Office grants a patent, the individual countries will grant a patent also. All right, so take over, Megan.
Very good, thank you.
Oh yeah, that's right.
So we can get this started. Any other questions before we transition? If anyone would like to take a break? We're good?
So maybe just another question on patent. So one control the world for patent offices and taking the jurisdictions and get those rights, is that?
Are you asking if once one patent office grants you rights in an invention, will other patent offices? Like Mark was saying, you have a 1 year after filing in a country to file around the world. And I worked at the U.S. Patent Office as an examiner, and one of the things I would frequently look at is whether or not Europe, for example, if they had examined the application before I had, whether they granted a patent. And I would take that under advisement, but I was under no obligation to follow what the European Patent Office did. So it
I'm
can't.
thinking of the case of a European company, let's say that doesn't do business in the U.S. I mean, someone could take that patent because now it's public and patent it in the U.S. and get an advantage here.
That'll be prior art. So the fact that it has already been published somewhere will be found by the U.S. examiner if a different company were to try to apply
So
for it here.
not patent.
Right.
Okay.
Any publication anywhere in the world, regardless of language, can be prior art.
And that is the kind of, when you were mentioning your publication,
Yeah.
that if you don't end up getting your patent, but it's been published, it is now prior art. So someone else cannot go out and then get a patent on that. So you're not protecting yourself, but so someone else isn't getting the same patent on that product.
Yes.
Okay, thank you. If I may add to that too, when you prosecute your applications in the foreign jurisdictions, as Dan mentioned, there are certainly different laws with respect to claims and claim form, but you are also, and in many cases this happens for us, we get different prior art cited against us in the different jurisdictions, which of course may change the arguments we have to make and the ultimate claim coverage we get in that particular jurisdiction. So for example, we might see some art in Europe that we have to argue against, we have to overcome to show that it's novel and inventive or not obvious, and we might get different art in Japan. They might have some Japanese references that the European examiner did not find. So you'll see differences too in the ultimate protection once you get that grant, once you get that patent, whether it's Japan or Australia or Europe. So you see differences in that sense too. Okay, thank you again for your time today. I'm going to take the second part of today's presentation and talk a little bit more specifically about U.S. patents. Dan did a real nice job giving us an overview of intellectual property generally and about patent system generally. But I'm going to get into a little bit more of the nitty-gritty of a U.S. utility patent. Jeremy's going to talk more about design patents, and that's of course a different type of patent, a different type of coverage that you can get for your designs. But just to get a sense of the group, has anyone looked at a U.S. utility patent before in the context of their business? No. Okay, good. We've got some examples here so you know what I'm talking about. I remember when you first come out of law school and you're learning patent law and you get to a patent firm and they're talking about all these patent terms and you're thinking, I've never even seen a patent before. So it's helpful to take a look at this so we can appreciate some of the terms. So we'll do that. We'll kind of go through the sections of the patent. We're going to talk about the process of obtaining it and then some best practices as well that hopefully you can take back to your groups that'll be helpful for you today. Great, perfect. Okay, so a little bit about the process here. Of course, at the beginning when you're working with your engineers, if you're in a smaller group and it's you and a couple folks, you have to conceive of the idea that will eventually get you patent protection, right? So the very first step is conception. And what is that? What do we mean by conception? Well, it's basically you have more than just a thought of, oh, we could try this, we could do that. It's an actual definite idea in the formation of the inventor's mind that, okay, I think this is an improvement in this area. And it's so definite that other people with the same skill of art, as Dan mentioned, this is a standard we use for obviousness, for example, with the same training, the same skill in the art, could take your idea and go ahead and make and use that, design, that product based on the framework of your conception. So if there's more to it than just, oh, this would be good. There has to be more meat to that. Another person, of skill in the art should be able to make and use that. The second part that we have here is reduction to practice. And while this is not required to get a patent, it certainly helps. One way you can show reduction to practice is actually make the product that you have conceived. Again, it's not required to get a patent, and that's why we have it sort of highlighted the way we do here. But again, it certainly helps to show that you have some meat to your invention, that there's something to it. The next part, and we're going to talk about this in a little bit more detail, is your invention disclosure. So if you're working with your engineers, if you're working with your team, if you're working with your colleague, and you really think you have something that's definite, that is different than what's out there, even might be a slight improvement over something you're currently doing, you want to describe that. You want to disclose it. You want to describe your invention. And we call that a concept record, an invention disclosure form, an IDF. And it will, describe how it's different, what you're doing, what it's maybe similar to, when you did it, did you show it to anyone, have you discussed it at a trade show, what has happened, and that's sort of our invention disclosure. At that point in time, a lot of folks will they might then contact their attorneys and say, okay, I have this idea, we're not sure we want to completely invest in it, we're not sure we want to spend the 10 to 15 grand to prepare that application, we don't know if it's patentable, could you please conduct a patentability search for us for a fixed cost of, let's say, $1,000, and we can certainly work with you on that. And we'll look at the search results and we'll say, okay, this is what's come back. We think there is patentable subject matter. We're not 100% sure. We don't know until it's prosecuted, but we think there is based on this art that we found, or that was found in the search. Or we'll say, this looks pretty close. If we are able to get a utility patent, it might be pretty narrow because we're going to have to get around this art in a relatively specific way that could narrow your protection. So, and that's certainly an ultimate business decision, but we find that in particular some of our small clients find that to be a helpful step. Another search that can be conducted as well, let's say that your intention is not necessarily always just to get a patent, but to make that product and be a competitor in that space. As Dan mentioned, you want to make sure though that you're not infringing on somebody else's patents, right? There's a lot of spaces out there, a lot of areas of technology that have a lot of patents. So you want to make sure if you're going to make this device, with an improvement that you decide not to patent for whatever reason, that you're not infringing someone else's patent. And so that's when we render these freedom to practice opinions, and we can have a freedom to practice or a freedom to operate search conducted for you. And we'll take a look at your proposed product in view of the art that was found in the search, and we'll give you essentially a clearance opinion. And we'll say, okay, you're fine, you're free and clear, or we found this patent. You might have to design around a little bit. You might have to modify your device and design around this patent so that you're free and clear and you don't run the risk of infringing. So that's another avenue that some of our clients take at this juncture, when they found this new product, they have an improvement, and they're trying to determine, if they want to make sure they're not infringing on someone else's rights, and they're trying to, be careful about the market. If you decide with your attorney, and this is certainly something that we can help you with, that it is patentable, and you decide that this is important to your business, and that's certainly a business decision. It depends on what you're hoping to do with that patent. What are your plans? Is this a flagship product? Is this a patent you'd like to get to boost your assets? And Jeremy's going to talk a little bit more about patent assets. But it depends what the goals are for your business. And if you decide that this is worthwhile, then you can go ahead and file, of course, a patent application, and we can draft that for you. At this juncture, Alex, you talked about too, you may decide that part of it you want to file an application on, and the other you want to keep as a trade secret. And we have folks that certainly do that. And there are a lot of specific steps that you can take that will show a court that you really did keep this secret, and it wasn't just you necessarily writing a few things down in your computer, but you made a lot of efforts to have all folks associated with this know that this is secret. Folks did not have access to it. There's a whole host of things that you can do. So at this juncture, they might decide, okay, yes, we want to file an application on Part A, and we're going to keep Part B as a trade secret. Or alternatively, we're going to put the whole thing into a patent application. Or as another example, we're not going to file a patent on this technology at all. So this kind of gives you a little bit of a framework for the process. We're going to talk a little bit more specifically about some of these concepts, in particular conception. So we talked about conception. You have to have that definite and permanent idea. These are some things to be thinking about. we work with engineers, we might have clients that are engineers in manufacturing companies in the accounting space, and some good practices are to have them write things down. This is kind of the good old-fashioned lab notebook we think of. Certainly it can be in your tablet, it can be in your computer, but when you're writing things down, date it, try to be as descriptive as possible. If someone is modifying something, when they cross it out, have them also initial that. So it's just proof that they made that modification, that they can get credit for that. If you can, if possible, have sort of a story in your tablet, in your notebook, whatever that is. So in other words, you don't have gaps in time, for example. You don't have big gaps, between pages of your notebook. They're showing that there's a consistent effort to develop this particular product or this particular design or this process or whatever that is. And that shows that you had this consistent train of inventorship and conception. Of course, the more descriptive, the better. If you've got a team of people, 2 or 3, it's better if they have their own separate tablets, iPads, notebooks, whatever it is, and they're separate records. Inventorship is a legal determination, and we can certainly help with that. And it helps if, it really can help if those things aren't all combined together. And the folks have, the potential inventors have some separate records for that. That certainly helps. Okay, this is some thoughts with respect to inventorship. We help a lot of our clients. They have teams of engineers that work on a product or a process, and they'll come to us and they'll say, we're not sure. We know that these 4 folks definitely were involved in the meetings. We're not sure if they're all inventors, and we help them with that. Inventorship is different than a co-author. To be an inventor, you have to contribute to that idea of conception that we will write in a claim to a patent. And I'm going to show you the claim in a minute. And that, of course, is the metes and bounds, what we like to call it. If you think of real estate, of real property, you've got your fence. For all the real property that we own, we have the very specific land lines and direction that tells us exactly what our property is. In the patent world, that's defined by the claims, which are in the back of the patent. And that delineates your rights, your right to exclude others from making, using, and selling the product that's covered by the claim or the process that's covered by that claim. So when we think of inventorship, the inventor has to contribute to the subject matter of that claim. So when we're drafting our patent applications, we of course share the draft with the inventors. And we, if there's an issue, typically they're all involved with all of those claims because we're drafting the claims to that same subject matter in unique and creative ways to get them the most protection. But, occasionally we'll have some inventors that were invented just some of the claims and others that invented the other claims, or rather are inventors with respect to some other claims. But it's different than a co-author. One issue that can come up is, again, when we're working in teams or even pairs, you might have a manager or director and they're directing that person to implement a new concept. That person who's merely implementing or following the directions with respect to the invention, that person's not an inventor. And again, this is a legal determination, but that just kind of gives you some bare bones. You have to actually come up with the concept that's part of that invention to be considered an inventor. The contributions need not be equal. You don't have to be in the same physical space. We have inventors that are in Italy, and we have some that are in Wisconsin, and they're inventors, co-inventors of the same application. So of course, as you can imagine, in today's modern world, we're not all in that same room inventing or working on that same technology. And again, this is a legal determination, and we could certainly help with that, and we help our clients if that becomes an issue. We talked a little bit about reduction to practice. How do you know if something's ready, right? You have an idea, you have a concept. Well, sure, it helps if you make it, but you don't have to have something made to apply and get a patent. Sure, it helps if you can test it and you can show test results, absolutely, especially if they're unexpected. There's an unexpected result with respect to that test. That definitely helps show that something is patentable. But you don't have to have it tested. Basically, you have to be able to describe that invention in our application in a form that a skilled person can make and practice that invention without undue experimentation. So that's what, that's what we're kind of looking at, and that's what we'll do as part of our disclosure requirements in an application. Reduction to practice can be an issue if there's an dispute with respect to inventorship. That's kind of outside of today's talk, but that can be an important set of facts if there's an inventorship dispute. We talked a little bit about the benefits to filing early. We are now a first to file country. We want to get things on file as soon as possible so that we don't inadvertently jeopardize the priority to that invention. And it's also easier to prevent others from patenting. You may have an earlier publication if there's not a non-publication request. Okay. Let me talk a little bit about this invention disclosure. I brought a sample here, and of course there are many different types of these. Some of you may have, is anyone familiar with an invention disclosure form? I've seen it, and there we go. This is what we call, as I said, a concept record or invention disclosure form, and this is just a sample that you can take to share with your group. Absolutely. And basically, this is one of our best practices that we'll talk about. If you take a look at this, it's really just asking you, okay, this is completed by whom, where were you, what problems existed, please describe the structure of your product, please describe the process for us, when was it conceived, who were any disclosures made to anyone, if so, who were they? And this is a very nice detailed sample invention disclosure form that you can take back to your group. Talks about the best way to know and make the use of the concept. Is there alternative ways this can be implemented? At the time of the invention and the time they're writing this, it can be helpful to ask the inventors, okay, yes, this is excellent. This is a really good improvement. We understand it. We see what you're doing. Is there another way you foresee a competitor doing this? And that helps us to try to get broader protection for our clients. And sometimes within those discussions, we really sort of push our inventors and they, come up with alternative ways. And then again, that helps us try to get the broadest protection we can for them. So we just thought we'd share that with you. You can take that back to your group. Of course, if you have manuscripts, figures, CAD drawings, anything in the context your inventors have that they used to develop the invention, that's always helpful to hold on to and to share with the lawyers and to include in your invention disclosure form. Okay, I wanted to talk a little bit about the process of obtaining a patent. So we talked about, all right, when you made that decision, when your company has decided to invest, maybe perhaps you've had a search conducted. Again, you don't have to do that, but you've decided it's patentable. You're going to go ahead and work with your attorney and prepare that patent application. We're going to talk momentarily about the claims and how those cover, again, the metes and bounds. We'll draft those claims, we'll draft the spec, we'll include drawings that explain what those claims are, and we'll go ahead and file that application. At that time, shortly after you file, we also will disclose to the Patent Office what we think is the most closely related art, or art that's relevant to their claims. The correspondence with the U.S. Patent and Trademark Office is an ex parte proceeding, which means it's not adversarial. So we are in an effort with the Patent Office to, if this application meets the requirements of patentability and all the disclosure requirements, then you have a good shot of getting a patent. But with that, you also have a duty to disclose the information that you think is relevant to the novelty and non-obviousness of the claims. So that duty extends to the inventors, anyone on your team, to us, to the patent lawyers, and this continues throughout the scope of the prosecution, throughout the length of prosecution until you get that patent grant. So you're going to go ahead and disclose that art. Typically, the first substantive review of your application will be 2 to 3 years after it's filed, unless you file a fast track application, which we call track 1, and you pay a fee for that, as you can imagine. I think it's about $5,000. But what you get with that, and several of our clients do that for different strategic business reasons, but what you get then is the Patent Office guarantees upon payment of that fee that they will have a substantive examination of your application and close prosecution within 1 year of your filing date. So that's significantly faster than the often 4 to 5 year time frame we're looking at. So if this application is particularly important, or there's a sense of urgency for you, we certainly can do that for our clients. The patent examiner is going to take a look at it, and we'll look at the art that's out there. That can be another patent, that can be a US publication, that can be a foreign publication, and then they'll cite that against your claims, and they'll say, no, look at this. This is really, we think this is exactly what you have in your claim. And then you have to amend your claim and make some arguments and assert that it's different than this art, and here's why. And so that can go back and forth for a year, a couple of years. It's very common to get a first rejection. It can actually show that you did a nice job writing some broad claims. In some cases it depends. And then there are different prosecution strategies. An appeal may be part of that if necessary. There's also continuation applications, a request for continued examination, that you can file as well. And then ultimately, hopeful allowance. We talked a little bit about these disclosure requirements. Dan touched on them briefly. When we write the application, we have to make sure that we disclose. This is kind of part of our duty. In exchange for that right to exclude others, the government requires us to disclose to the public what that invention is. So we can't hide the ball. You have to be very open and describe enough information so that someone of ordinary skill in the art will be able to make and use it without undue experimentation. If you have a preferred embodiment, a preferred example, it's good practice to note that as well, that while this is not required, our preferred way of doing it is X. That's also one of our disclosure requirements, the full breadth, and then also, of course, a use. That's what we mean by a utility application, that it has some use. And that's usually a very easy thing to do in this sense. This is our duty of disclosure. As I mentioned, it's ongoing throughout the application. Anyone who is aware of any art, again, that could be a patent, a publication, an article, a journal article that they think is relevant to the claims that you have on file, you want to go ahead and disclose that. And then the patent office will take a look at that. And that's just good practice for folks to know about that. So let me pass out now. I have a sample patent. This is kind of branching off of our Coke example. This is not Coca-Cola's patent, but it's a utility patent that's directed to a can, a beverage can. So as Dan nicely talked about, you can get a trademark, of course, to the Coca-Cola logo. You can have a design patent. You could have trade dress to the formation of the can. Wanted to show you, this is an example of a utility patent. So now you can say you've all seen one. And if we look at the very back, the second to last page, you're going to see in column 6, about the middle of that page, the first claim. And again, that's the property, that's the intellectual property, that's the patent right that this inventor has rights to. And if you look at claim 1, it recites a beverage container comprising a bottom wall, a top wall with the liquid outlet, where you drink the liquid, and then a side wall. And in this invention, they had what they refer to as a generally nose-shaped inward indentation. And you can see that in the figures. And this was important because it helped the flow of the drink, and it also helped the user easily grab the can and know right where that liquid outlet was as well. So these are the claims in the back. You'll see that also the parts of the application, we have our figures, and those are in the beginning of the patent. And when someone is trying to understand what the claims mean, you're going to look at the figures and what we call the specification, which includes the detailed description of the drawings, the detailed description of the disclosure, the background, and we'll look at all of that together to understand what the claims mean. The patentee can be his or her own lexicographer, which means that we can give meaning to a claim term. That's different from the ordinary meaning. And so we're looking always to the spec to see if the writer did that. Oftentimes, he or she did not, and it's the common meaning that's known in the technology, but we have to look at this and understand what these terms in the claim mean in relation to the spec. So we've got the figures and drawings. The spec mode is the US requirement. We talk about disclosing that preferred embodiment. You see the single sentence claim, and these terms relate to the spec. So that just gives you a sense of the contents of our US patent.
Were they awarded the patent?
They were, yeah, that's an
I
actual.
haven't seen it in the market.
Yeah, that's an actual US patent. Yeah, you haven't, so you'll see that a lot of patents that are issued don't necessarily make it to market. Clients have a lot of different ideas in terms of use for that patent, but yeah, a lot don't necessarily make it out there. So a couple things, how is your team involved with this process? What time are they going to have to dedicate to the patent process should you decide to file some applications? As we talked about, they have to be aware of any prior art that comes up. If they have a new journal article, if they have a magazine that comes through, if they learn of a patent in the context of another job or another project and they think it's relevant to this pending application, we want to disclose that. They might review some of the search results. After we write the application, we'll send it to the inventors and your team, and they'll look at that application and let us know if it's accurate, technically accurate, if they had any modifications. They might participate in patent prosecution. Sometimes we have folks look at our office actions, which is the correspondence we receive from the patent office, and they'll say, oh gosh, no, this has nothing to do with our claims. The patent examiner's got it all wrong, and here's why. And so sometimes we'll have folks help with that, and then also they might advise us with later patent filings and strategic considerations for continuation applications. Third-party patents, similar idea. Let us know. We're asking your team, your engineer, your inventor, let us know if they have learned of a third-party issue, maybe at a trade show. Maybe they are out and about selling something and they learned of a competitor product that they think is similar. We want to know about that. They'll help us understand and maybe explain to us some of the patented technology, and also can assist with potential design arounds. And that's when you're looking at that claim in the back of your patent, and you don't want to patent something, right, but you want to enter the market and you've asked for a freedom to practice opinion or freedom to operate opinion. And you might come up with a patent that you think is problematic, so you have to design around the claim of that patent. So sometimes the engineers will help with that too. So I'll close with a couple things, some best practices. Of course, we want to file the applications before any public disclosure. As Dan mentioned, in the US, you may have a year grace period. In most foreign jurisdictions, that public disclosure, you're forfeiting your rights, your patent rights. So that's really important if you have a trade show coming up, if you're disclosing it to a third party, to a vendor, if you're going to offer it for sale, you want to have something on file. It's the best practice. And we can file a provisional application for you. If you're not sure you ultimately want that to be published, remember, provisional applications are not published. It's a placeholder, and then if you decide within a year to file the non-provisional, gives you a little time, and we can do that for you. You want to be kind of thinking about your intellectual property throughout the design process. If your engineers and your team can be aligned with us, it just makes for a more seamless process. They're writing things down, they're tracking their notes, they're dating their iPads and their lab notebooks, they're noting why it's different, they're keeping a good record. That's very helpful. Small improvements may be patentable and may be valuable to your business. Many patents that are issued are small improvements and can have a real benefit and value to our clients, in particular to small clients. So you want to be thinking about that. Providing that concept record, that invention disclosure, trying to complete it as much as possible, attaching any figures, and then sharing it with your patent counsel. Using confidentiality agreements when you're disclosing it to a third party. We like to, even if you have something on file, to be extra careful. And then, of course, remembering always that duty to disclose. You know, it is an ex parte proceeding. In other words, it's not adversarial. So part of our duty is we have to disclose to the Patent Office throughout the pendency of the application anything that we think is relevant to the claims. So that wraps up my part of it. We thought we would take some questions now and then take a quick break before Jeremy begins his part of the presentation. Does anyone have any questions?
Yeah, this whole trade show idea has got me scratching my head. So the trade show's in Chicago.
Yes.
This guy's from Japan.
Yes.
I talked to him about this idea. He goes back to Japan. If I disclosed my idea to Japan now, I'm not, the trade show's here. I'm not going over there talking about my idea. I mean, if as long as I make this person sign confidentiality,
Yeah.
I might show him something like this.
Right, right.
He goes back to Japan, does it prevent me from potentially filing for a patent in Japan?
Yes, it could. Yes. So what we do before, and then we're trying to always get ahead of that, and we're telling our clients, if you have any trade shows, if you have anything coming up, let's get something on file before then. Because in particular in the foreign countries, you could jeopardize, that disclosure could jeopardize your foreign rights. And the laws of the foreign countries vary, but yes, that would be a problem. Any other questions?
Well, if we could get started again, there's not too much to go. We're almost home. Wanted to take you real quickly through design patents just for an introduction of what those are. I think they got a lot of publicity in the Apple and Samsung litigation. People woke up and said, wow, a 9-figure, 10-figure damages award based on a design patent. I didn't know they could be so powerful. And the main reason behind that is because, unlike a utility patent, even though a design patent protects only the ornamental features of a product and is therefore considered more limited in a way than a utility patent, there's something that a design patent gives the patent holder that a utility patent can't, which is potential damages, including the infringer's profits. And in a typical utility patent infringement case, the damages are limited to a reasonable royalty. In some limited cases where you have a two-supplier market, you might be able to prove the patent owner's lost profits. But sometimes an even more lucrative or attractive potential damage award to the patent holder is the infringer's profits. And that's what you saw play out there, and that's why we see a real land rush to design patents. So just to give you a little bit of an introduction of what those are, as Dan mentioned, they protect the ornamental appearance of an article of manufacture. A couple samples here, a filter, the previous version of the Apple product that we all know and love, the iPod. You'll see that certain features of the drawings can be shown in dashed lines and certain features are shown in solid lines. So in this case, the circular disc that the user would use to select their songs or change the volume, and even the shape of the screen itself, if you look closely, those are shown in dashed lines. And in a design patent application, you can use dashed lines to essentially disclaim aspects of the design that you don't want to be limited to. So in this instance, the patent owner was going for the ornamental design of the overall shape, and had dashed out some of the internal details of it. So those are some strategies that we try to employ to really tease out the most generic version of the ornamental design that we can possibly protect. While a utility patent will protect the way a product functions, the design patent protects the way it looks. The legal requirements very similar to a utility patent. They still have to be novel and non-obvious and meet those requirements. But what we've seen, and I'll skip ahead a few slides, is that the allowance rate of design patents is tremendously higher than utility patents. Part of this may just be that there are fewer design patent examiners and a tremendous amount of design patent applications being filed. But even before this sort of land rush to file design patent applications, we saw allowance rates significantly higher. It may be that the patent examiners have fewer prior art resources at their disposal, even though they do have access to the internet and they're getting better at searching. We still tend to be bullish on design patents because with an allowance rate over 80%, the relative cost to a utility patent is lower, and just recently the international landscape has been one that's caused the United States to give a little more protection. The term of a design patent recently changed from 14 years after issuance to 15 years. You wouldn't think the addition of a year makes that much of a difference, but it certainly can. And if you're strategic about the way in which you file your design patent applications and maybe include several embodiments of your design in a single application and sort of force the examiner to make you file a set of divisional applications, you can have these design patents of varying scope and they can sort of cascade in their expiration. So you're really keeping your competitors at bay for even longer than 15 years, sometimes 16 years, sometimes 17 years. And at the outer stretches of this, we can envision circumstances where your design patent protection actually outlives the utility patent protection you'd otherwise be able to get. The term of a utility patent runs 20 years, but it's 20 years from the filing date of the first non-provisional application, whereas a design patent, the term is based on the issue date of the patent. There is a new feature called the Hague Community Design Application, which allows you to file internationally. So just as utility patents are only good for the territorial jurisdiction where that patent application is filed, a design patent would be valid for the United States and its territories, but wouldn't cover the design, let's say, in Canada or Korea or Japan or Australia. So you do have to file separate design applications in each of these countries. Unlike the 1-year grace period you have to file a foreign utility application, the term for design patents or design rights in foreign countries is only 6 months. So from your US filing date, you are on a shorter time clock if you want to secure foreign protection for your designs. It's only 6 months. But with this new Hague Convention filing, not all countries are members of the Hague Convention yet, but more and more are signing up. The United States and Korea and Japan just joined in May of last year. So we now are offering the avenue of filing this sort of international design application that will still in certain countries have to be processed by the individual countries, but at least it gives you a one-stop shop for filing. And you would designate that certain countries that are members of the Hague Convention where you'd want protection and avoid this need to, say, file first in the US and then 6 months later in all the other foreign countries. So keep that in mind if you're interested in international protection of designs. I want to shift over to a discussion on branding a little bit. So the importance of brands, as Dan mentioned, it can be the leading value indicator, the leading equity source for a company can be its brand. And it's sort of hard to get your head around sometimes because a brand just seems so ethereal. It truly is intellectual property, but if you look at some of these brands that have lasted over 100 years for those companies, they truly put a lot of stake into their trademarks and into their logos. So even for a small company starting out, they shouldn't overlook the process of applying for protection of their brands. a couple of reasons you might want to seek protection for a brand, or at least look into the possibility of registering a trademark, is if you do a search, particularly if you're launching a new product, but even if you're branding a new company, you want to make sure there's not a competing product already on the market with a name that's so substantially similar to the one you're about to come out with that you might get sued for trademark infringement if you were to come out with that product. So this is something that our trademark group could certainly help perform the required searches to give you not only a good sense of whether the Patent and Trademark Office would likely grant a registration, but also be clear that you're not going to be stepping on the toes of a competitor with a perhaps confusingly similar trademark. I think that when you look to protect a new prospective name or brand or logo, it's best to do so very early in the process. You don't want to get too wedded to a particular name only to find out late in the process when you go to do your search that it's already taken, and you may have already taken steps toward labeling and printing of user manuals or maybe even molds for a product, and have to go through the costly process of changing all that. So we recommend doing this early in the process, and frankly I found it best to come up with 3 or 4 different alternatives that the team can live with, so that if their first choice gets shot down early, they don't leave disappointed. They can see, okay, well, this one option is maybe foreclosed, but there are 1 or 2 other options that look more favorable. Keep in mind that the internet domain name might be something of interest to you too. It's easy enough to think of maybe a variation of a domain name if the domain name you want is taken, but there are many benefits to trademark registration, and one of them is if you have a registration, it's a lot easier to go after somebody who has tried to register your domain name, to maybe register your name as a domain name to try to divert traffic to their site, particularly if it's a competitor, but even a cyber squatter who might want to extort some type of a payment from the company to sell the rights to the domain name to them. We don't see this as much now that there are some laws in place, but it still happens, and having a trademark registration puts you on far superior ground as compared to companies that don't. It can also be a deterrent to your competitors. So if you have a trademark application on file, even if it hasn't registered yet, a competitor who is coming up with their own products and presumably doing their due diligence and checking to see if prospective names they might be looking at for their products will see that you filed a trademark application on a particular name or logo, and you might not even know the deterrent effect that your filing may have had. But we do hear, at least anecdotally, that having the trademark application in place is a serious deterrent to competitors. Another benefit of a trademark registration is that you can register that with the U.S. Customs Office. And Customs and Border Patrol, you'll see this a lot in the consumer goods arena, where if a luxury brand, but it doesn't even have to be a luxury brand, but frequently you see this, will register their trademarks with the Customs Office, who will then help that trademark registrant by looking for infringing goods coming across the border. When you think about trademark registration, you should think about it not only in the U.S. but also abroad. Even if you're only selling your product in the United States, if you're manufacturing that product in foreign countries, you want to be sure that you have registered your trademark in the foreign country as well. We've seen situations where, for example, a U.S. company has their products manufactured in China, and the product comes out of China branded with the trademark on it already, and there have been instances where the Chinese export authorities have seized the goods and said that, well, these goods are bearing a trademark and we will not let these goods leave the country unless the owner of the trademark presents their registration. And we've had to scramble on behalf of that company and obtain Chinese trademark registration rights, and those goods could be held up at the export authority in a foreign country for a long time. So you want to be thinking about your supply chain. Another fear is that it would be perfectly legitimate for a competitor to register that trademark in the foreign country if you haven't gotten there first, or your clients haven't gotten there first. So you want to make sure that they don't just set up as you in that foreign country and come out with very similar branding to yours, trade on your goodwill, and really cause a headache for you that frankly the local authorities might not be very sympathetic to. So you certainly want to be thinking, if you're a global company, or even if you're a US only company with eyes toward expansion, or you fear there's a likelihood of a competitor expanding into a jurisdiction you're not in, to look to seek trademark registration in other countries. And it can also give the trademark registrant standing to sue in federal court, which just relying on common law rights, saying, hey, we've called ourselves this, or we've called our product this for years, everybody knows it's us, why should we get a trademark registration? Well, that might not be enough. That goodwill or common law right you may have in the mark would typically not be enough to get into federal court to stop an infringer. And another benefit of having the trademark registration is damages all the way back to the date that you first started using the Circle R mark. So one thing that we see trademark owners not always understanding is that there's significance to when there's a superscript TM after a brand name, and there's also significance to there being the Circle R. And the Circle R actually cannot be used unless and until the U.S. Patent and Trademark Office has examined the trademark application and granted a registration. Once that's happened, the use of the Circle R is important because you can get damages all the way back from the time that you first started properly using that R in a circle mark. Whereas prior to the grant of the registration, you would just use the superscript TM to designate that you think you have exclusive rights to that mark, but you're not able to use the trademark registration symbol until it's actually registered. And I kind of gave the context of these slides without going through them all, but the slide deck is in your materials, so you'll have those with you, and please feel free to reach out to Dan or Megan or me with any questions. Should you find that your company is on the receiving end of a patent infringement suit, patent litigation services is certainly also something that our firm helps advise clients on, and we help look for creative solutions. Sometimes it is in cross-licensing technology to the other side, but sometimes you really have no choice, and you have to fight it out, and that can be a very very extensive drain on executive resources, and it's good when you're on the receiving end of even a cease and desist letter to get patent counsel involved early, so that you don't make any missteps on the way that could prove costly later. Thank you very much for your attention.